class where we already have a list of who's going in what order?
Yeah.
Should I pull that up? Order of practice arguments in 45 class. That is a precisely titled document. Order. So who went last time? Did Michaela go last?
I did.
So it's
no,
Leah?
Leah went last. I went.
You're not just pretending so that you don't have to go this time?
You don't even remember?
I think I went. I went last.
It was spectacular.
Thank you.
All right, so Shari's up now. Is that right?
I already went.
Yeah.
You weren't even here.
Touche. You don't get to take spring break early and skip. So okay, I'm going to tell you a 2-minute story that I find anyways, and then we'll do Ask Me Anything, and then we'll do the practice oral arguments. How's spring break?
And
Great.
I had an escape room.
You had a what? An escape room?
It was fun.
Did you escape?
15 minutes, 44
My
seconds.
cousin loves that thing. I've done it 3 or 4 times. I will say I'm like, nah.
So where you pay to get kidnapped?
That would be cool. Where was that?
Atlanta.
Oh, I was gonna say, if it were Harry Potter, I know some people would go do it.
It kind of Harry Potter, and it's like all Harry Potter.
I have fun with them. Who's done one of these escape room things? About half, a little less than half. I have fun with them because I enjoy like the experience with friends, but probably not more than if like we were sitting around a table chatting. So, I don't know.
That's why we do it with strangers, make it more entertaining.
Oh no, I don't like strangers. Emily, I'm gonna give you a little
I don't
advice.
know
Here's
what
a practice tip of the day. Practice tip of the day, especially for Emily. Don't talk to strangers.
That's actually a good one.
And don't take their candy. Definitely don't take their candy.
But
Okay,
you're-
so
how do we make money as a lawyer if we just can't talk to strangers?
I don't know. Well, let's see. What was I going to tell you? So on Monday, here was my original travel plan. Wake up at 3 a.m. I worked until about 1 a.m. So sleep 2 hours, wake up at 3 a.m., take a flight to Charlotte, and then a flight to Lynchburg, Virginia. Then give a talk, then drive an hour, then give a talk, then drive back an hour, and then take a 7 p.m. flight to Charlotte, a flight from there to Louisville, and get in at midnight. So I planned a 21-hour day. And I'm telling you this because it got much worse. Much worse. The flight out of Lynchburg coming home was so delayed that I was going to miss my Charlotte connection. And I never thought I would say this sentence in my life. I really wanted to be back for the faculty meeting yesterday, which was at noon, because I thought we were going to discuss a topic of interest to me, which we ended up not getting to, which is fine. So I was like, I got to get back by noon. How am I going to do this? So let's just I'll take your ideas. What would you have done in this situation? Lynchburg, just so you know, its airport is the size of this classroom. So there were no other flights out of Lynchburg. Like our plane was the plane, and because there was maintenance trouble, that was the issue. They had to call a maintenance crew from Roanoke, Virginia, which was about an hour away. So you're in Lynchburg. It's 7.5 hours from Louisville. By this point, it's 9 p.m. What's your plan? Drive?
Get your 10-minute
Now here's the thing about driving. I've been up since 3 a.m.
Yeah, you
Make
got
sure
2 hours
shots
of
in order,
sleep.
then get a Greyhound.
Get a Greyhound, okay?
Shots
Emily
in
votes
order
for
first.
Greyhound. Shelby voted for Drive while you're exhausted, which sounds super safe. Any other ideas?
How far is the nearest big airport, like DC or something?
Good question. Probably in the ballpark of 2 to 3 hours. Charlotte's 3 hours.
It's halfway to Louisville.
And there's a chance I can wait for the flight that night to Charlotte at 11 p.m., assuming that like they actually fixed the engine, and it was the engine that was broken. It wasn't like
Oh.
yeah, not doing on a plane with that. And so I could fly to Charlotte, get in at midnight, then take a 7 a.m. Charlotte flight to Louisville.
Take an Uber.
Take an Uber.
I'm kidding.
Ooh.
That's what I did.
Wow.
Kelsey, you nailed it.
That
would have been so expensive.
Well, I should also add this factor. I'm not paying for any of this.
Oh, that's
Take it
And neither is
Uber.
the school, so don't worry. It's not like your hard-earned tuition dollars that work here.
How much was that?
They told me it was going to be $550.
Oh, that's not.
yeah.
It's like for basically you're being chauffeured 500
I mean,
miles.
people pay more for it.
That's like a flight.
Yeah, it's like about a one-way flight. On short notice, it's a one-way flight.
Right.
That was a happy drive.
I mean, I gave him the choice. I gave him about 5 times to opt out before we did it. I was like, "Are you sure you want to do this? Are you sure you want to do this?" And he probably should not have done it in hindsight, because by the time we got to Lexington, he was doing like,
Oh my goodness. Oh my goodness.
gosh, you know, he wasn't like saying that, but he was doing those facial. He was doing the exact same facial motions that I used to do in college when I should not have been driving because I was too tired. So I slept, you know, obviously, almost the entire drive.
That's gonna be a story for the rest of his life, though. Probably. Like, what's the farthest trip? Well, one time.
All right, and the last wrinkle is that about 3 hours into the drive, we're in West Virginia. I'm sleeping. He starts telling me something while he pulls over on the side of the highway. And what he says is, "Why did you cancel the trip?" I said, "I didn't cancel the trip. First of all, why would I cancel the trip? Secondly, I was asleep, so I didn't do anything. But the app had canceled the trip. And so he was worried that he was not going to get paid
Oh,
for what was a 15-hour round trip for him.
he was about to throw
so-
you out.
He said, "I'm going to turn around and take you back until you figure out a solution to this." So I said, like, at least don't go backwards. Let's just, like, stop. So but he would not go forward. He would not, like, keep driving while I called Uber. So for 30 minutes while I worked it out with Uber, we were on the side of the highway at 3 a.m.
Oh
just
my God.
sitting there wasting time.
That sucks. That's weird.
He did not get a tip.
Did the talks go well though?
The talks went great. So, anyways, that was my day. Okay, so ask me anything. Any questions? Any questions about oral argument stuff? Yeah.
Do we
sorry.
have to go 15 full minutes, or can we end a little early?
You should probably
Well,
not
that's
end
all.
more than a minute early. In fact, I think it's advisable to go 15 minutes, especially in practice. In real life, no. In real life, like, if you said everything that you feel like you need to say, I think it's kind of like a sign of confidence, a projection of confidence to say to the court, if there are no further questions, we rest in our briefs, because it suggests that, like, you think you've got it won. But it's not overconfidence either. It also suggests you don't want to waste the court's time by just, like, filibustering. But you will get penalized in the first year oral argument competition, not Saturday. Saturday's not a competition, but if you end early. And so Saturday is good practice for not doing that. So don't end early. Good question. What other questions? Oral argument stuff. It's going to be
So
here.
it's
Everybody knows
15
it's going to be here. Your panels will have 2 to 3 judges, I think. I think it's 15 minutes.
Okay.
Only
I thought it
because
was
that's what
12, so
Showery told me.
that's good.
But now you're telling me it's 12, so.
I'm pretty sure.
And you have told me nothing but true things today, and Showery has told me, so far as I know, nothing but false things today. So could easily be 12 minutes, people. Yeah, Nicole?
So I know we get up here and we're only doing 5 minutes. So are we just restating our argument as we go, and is it 15 minutes per side, or?
You mean on Saturday?
Yeah.
So on Saturday, I wish we had the moot court. Zach is on the moot court board. Why don't I text Zach right now and ask him, and then either way, I can answer your question. How long is each oral argument Saturday? Okay, so let's say it's 12 minutes. You're the government, I remember. But the government goes second. So let's say you're going up against Elizabeth, and Elizabeth's the defendant. So Elizabeth will get up. Elizabeth will ask to reserve 2 minutes of her time, and so she will speak for 10 minutes. And in those 10 minutes, ideally, she'll start with about 30 seconds worth of stuff, and then get interrupted with questions, and then be asked questions for 10 straight minutes.
Okay.
That's what should happen. If her bench is a quiet bench that doesn't ask enough questions, then once they've stopped asking questions, Elizabeth should talk and use that time to further explain why she's right. That's when you can kind of revert back to your outline, and expand on primary purpose, apply it, expand on formality, apply it, expand on surrogate witness, apply it, and fill up the time. And some of you honestly that will probably happen to some of you because we can't control exactly how active each bench is. But hopefully most of you will get questions for those 10 minutes. So that's we Elizabeth's 10 minutes, then you would come up. Same thing for you, you'd have 12 minutes. You might start with about 30 seconds, a minute, get interrupted, answer questions. Hopefully they'll keep asking you questions. You go the full 12 minutes, and then when you're done, Elizabeth gets 2 more minutes. It's done.
And they'll know about our case before?
Yeah, so they're gonna receive a bench memo. I think they probably already received it by email. Most of them will probably skim it for the first time that morning.
Okay.
But it's a pretty good bench memo. Like it's pretty concise, and it doesn't require, I think it will, whatever. They'll know almost nothing. But that's actually not totally unusual for an appellate court. I mean, a real appellate court would have gotten your briefs weeks in advance and should have read them, and their clerks write a bench memo, and they should have read the bench memo from the clerks. But, some judges come to oral arguments very prepared, and some judges are lazy. And either the trial level, it's even more so, that you might have filed a 10-page motion to exclude evidence, and then get there for the hearing on that motion, and the judge will either say or make it very clear through his or her actions, I have not read your motion. I have no idea what the hearing is about. Tell me why you should win. So it's good practice for overcoming a very big knowledge gap where you have a lot more. By the end of the day, this is a little different dynamic than in real life. By the end of the day, the judges will know a lot more about this case because they will have heard 4 or 5 oral arguments already.
Mm-hmm.
So that can be an advantage or a disadvantage if you're going later. Advantage because they'll be able to ask better questions. Disadvantage because they will know what they're talking about enough to kind of call you on stuff if you're way off base.
So you can't lie about
I mean, not in a
it.
rude way, but they're in a better position to ask a high quality follow-up question. What else? All right. So shower is up. Let's do it.
So you just go by yourself? You go by
I
yourself?
need a seat right there. Who else wants to be practice judges? Any volunteers? So much fun. Come on. This is your last chance to be a real judge for at least about 4 years.
I'll do it.
Yep, and he's on a seat. Good. Get out of here.
Just a seat over here.
So you go by yourself? You don't go against anyone?
He's not in my way.
Yeah. Oh.
Okay, so there's no volunteers to be judges.
Were you not here on Friday?
No.
All right, so come take someone's seat back here. What else? We have one more. Handle 3. You want to be a judge? No.
No.
All right,
I don't have any experience.
Jesus.
I'm just
Right here.
really even put myself in that.
Is there gonna be a thing on us everyone?
There's not a clock, but there will be a student volunteer who's the, what do they call that person? Timekeeper, but I think it's supposed to be the court bailiff. And they'll tell you, I think, when you have a minute left and when you're out.
He's gonna be in the back of the room. 39.
You were.
Okay, so I am going to ask tougher questions today than last week because the reward for people going last week was softball questions. I'm not going to ask any unfair questions. And if you're not prepared for an answer, then do your best. But this is not low stakes. This is no stakes. So just a chance to kind of get your feet wet a bit. But I do think that I will try to give you an idea of the kinds of questions that the judges will be asking, or maybe more precisely, the kinds of questions that the judges should be asking. Okay, let me get my stopwatch out. Okay, so Zach says that it's 15 minutes per side.
That's what I thought.
Thanks. Yeah, I'm not tenured, so. Okay, go ahead. Ready when you are.
Good morning, Your Honors. May it please the court. My name is Shario Belanki, and I represent the appellant Ronald Miller. At this time, I would like to request 2 minutes for rebuttal.
No problem.
Thank you. This court should reverse the decision of the district court because Mr. Miller's rights under the Confrontation Clause of the Sixth Amendment was violated. Mr. Miller's constitutional rights were violated for 2 reasons. First, the autopsy report is testimonial because it satisfies both the primary purpose and the formality test.
Can I stop you there about the 2 tests? What tests should we apply? I know you're going to talk about both of them, but assuming you can pick, should we apply the primary purpose test? Should we apply the formality test? And maybe another way of thinking about it is, what if one side is going to win one test and the other side is going to win the other test? Which is the better test?
I think both the tests are pretty equal, but if I were to choose, I would say the primary purpose test is more important.
Can you tell me a little bit about why?
It's been regarded more in the past. It is the more popular test, and the formality test exists more because if the primary purpose test is insufficient or has some weaknesses, the formality test exists to compensate for that.
Great.
The second reason that Mr. Miller's constitutional rights was violated was because Dr. Adler's surrogate testimony was an insufficient substitute for Dr. Hines. The autopsy report is testimonial under the primary purpose test because the primary purpose of an autopsy report is to establish evidence relevant to a later criminal prosecution. The Davis v. Washington, ever since the landmark case Davis v. Washington, the Supreme Court developed the primary purpose test to differentiate between testimonial and non-testimonial statements. The court there defined evidence.
Let me interrupt again. That is all very helpful. I'm going to go ahead and move to the application of that primary purpose test. As you know, when Dr. Hines performed the autopsy, he believed he was dealing with a suicide. There was not any suspicion that a crime had been committed. So how could the primary purpose of what he did be to produce evidence against Miller?
I would argue that there was a suspicion that a crime had been committed because the autopsy test was conducted. There would be no reason to conduct an autopsy test if there was no suspicion that a crime had been committed. In our case,
just to follow up to that, because you have persuaded me that there probably was suspicion. So I agree with you. You correctly did not run with the false premise of my question. But I do think that there are purposes of an autopsy in addition to criminal investigation. Would you agree with that?
Possibly.
I mean, let's say that a loved one of mine passes away unexpectedly, and there's no reason to suspect foul play, but I just want to know what my loved one died of. It seems to me that happens all the time. Isn't that an example of an autopsy with no criminal investigation purpose?
That is an example, but that is not what we have here. In this case, the autopsy report was conducted specifically to determine if it was a homicide and not suicide.
Great.
There are 2 crucial factors that suggest the primary purpose of the autopsy report was to establish evidence relevant to a later criminal prosecution. First, medical examiners are required to notify law enforcement when a death has been labeled homicide. And second, Dr. Hines wrote the word homicide on the report. Hence, Dr. Hines knew writing homicide meant being obligated to notify law enforcement.
Excuse me, I just got a quick clarification. Sorry to interrupt you right there. So when you said that Dr. Adler is not a sufficient surrogate witness, where are you getting those cases?
Consistent with precedent, he's not a sufficient surrogate witness. For example, in the case Bullcoming v. New Mexico, the Supreme Court determined in a similar fact pattern that the testimony by a surrogate analyst was inadmissible and violated the Confrontation Clause.
Okay, so let's stop there. Great job. Wow. I think Phil was about to ask a question, but we were well over, so you can save yours for the next person, or at least the next defense side. So, I mean, that was, I think, like about as well as it could be done, honestly. But we asked 3 hard questions. I asked 2. Alex asked 1. And you kept your cool. Your tone was great the whole time, and your substance was great. On the first question, which test should we apply? I think that your answer was not only right, it was well supported, it was well reasoned. I mean, the primary purpose test is the better test because it's the one courts use the most. So if I'm a lower court and I'm trying to figure out like which test should I use, okay, yes, Justice Thomas likes the other one, but pretty much everyone else prefers the primary purpose test. So it's a good answer. The second question, I think you were correct not to accept the premise of my question that that Dr. Hines, had no suspicion of any crime. I mean, like that, she was shot, so there can always be some suspicion. Not to mention that there was no suicide note and other things that might have led to suspicion of a murder. And then I thought your answer to Alex's question was good. It's a good bridge. For example, and then name a case. It's a good thing to keep in mind in terms of how to answer a question. Alex said, give me a case. You were able to give him a case, and you actually gave him the best case for the defense on the question of surrogate witness, because it's a Supreme Court controlling case, and it deals with a surrogate witness, and the defense wins it, unlike in Williams. Other thoughts on Sharia? There, we're going to go in order. So I think we went this way last time. Where did we stop?
I went last.
You went last? Okay.
No, not me. Don't talk to me.
Jacob, what is Sharia do well?
I guess kind of summing up, which I think just answering the questions were really solid.
Good.
You did kind of post like a little juke out there.
Yeah, I mean, I think we tough questions, and you did, not only did you answer them well, but he didn't dodge them.
Yeah.
So good. Okay. Next.
Man, great job.
Can I ask you a question?
Yeah.
So this might be stupid or a technicality, but so I'm confused on coming from either side. If you were to say that it satisfies the test or
Yeah, that's a good point. I guess usually you should make clear in the context, like the government cannot satisfy its burden on the primary purpose test, or the defendant cannot satisfy its burden on the primary purpose test. And let's say I say the defendant cannot satisfy his burden on the primary purpose test. It means the defendant cannot show that the primary purpose test is going to lead to a good result for the defendant. I would try to phrase it like that as opposed to just saying the test is not satisfying. The primary purpose is not satisfied. Well, who's failing to satisfy?
Okay.
Make sense?
Yeah.
Okay, we're ready when you are.
Good morning, Your Honors. May it please the court, my name is Elizabeth Clements.
Go ahead. I'm going to get what I'm saying. Actually, you were a little quiet on volume. I was trying to give some suggestions, so project it. Okay, let's start over again. We're ready when you are.
Good morning, Your Honors. May it please the court, my name is Elizabeth Clements, and I represent the appellant, Fatima Miller. At this time, I would like to reserve 2 minutes for rebuttal.
No problem.
So a brief summary of the facts. Mr. Miller.
You can skip the summary because we're good.
Oh, skip all
Thank
that?
you, though. I appreciate the offer.
Okay, give me that. So the main issue on appeal here is whether Dr. Hines' autopsy report was considered a testimonial statement, making him an adverse witness against Mr. Miller. At trial, a surrogate witness, Dr. Monica Adler, was used to replace Dr. Hines as a witness. And this was not appropriate and violated Mr. Miller's Sixth Amendment confrontation rights because the autopsy report was in fact a testimonial statement, meaning the primary purpose test, because the statement author was very entangled with law enforcement throughout the creation of the report. The statement author, Dr. Hines, knew that the report would be used as evidence in a future trial, and when the statement is a forensic report, as the case is here, the report's validity depended on Dr. Hines' skill and judgment as a medical examiner.
Do you think that the autopsy report targeted a specific individual?
I believe in this case that it did, because Mr. Miller was the only suspect after the autopsy report was created. Law enforcement was involved from the moment that he made his 911 call all the way through the actual submission of the report to police. The law enforcement officer who appeared at the scene first was also there throughout the process of the autopsy. So there was a law enforcement official who knew that he was the only person home at the time
Do you
of
think
the
that
death.
Dr. Hines had even heard of Mr. Miller's name?
I don't believe we can know that unless we call him as an adverse witness. But that is very, very likely, considering that the actual officer who appeared first at the scene and questioned Mr. Miller was present at the autopsy itself.
Assume, as persuasive as those two answers were, that I'm not persuaded. That I think this autopsy report did not target a specific individual. Does that mean you lose, or can you still win?
I do not believe that means that we lose. In this case, whether it targeted a specific individual, Mr. Miller, or not, the medical examiner, Dr. Hines, knew that the report would trigger a criminal investigation and lead to a trial because he determined manner of death was homicide. And the only two outcomes from the autopsy report would have either been suicide or homicide. So it would have either confirmed there was no criminal trial possible, or there would be one.
Does it interrupt? Let me ask one more question, and then, because it's a follow-up to that. Doesn't Williams v. Illinois say that a report is not testimonial when it does not target a specific individual? And if that's the case, doesn't that mean, assuming that I think this does not target a specific individual, that you lose?
Williams v. Illinois may say that, however, it is not a binding, it's not binding precedent, it's a plurality opinion, and it is also distinguishable from our case because in Williams v. Illinois, the DNA analyst who did the report had no way of knowing whether or not what they were reporting would turn out to be incriminating or exonerating, whereas in our case, Dr. Hines knew that what he produced would be incriminating to some individual.
You mentioned that Dr. Hines knew that the report would be used in a criminal prosecution. Where are you seeing that? What evidence do you have to suggest that he knew?
The fact that the state autopsy protocol for the state of Indiana specifically says that pathologists are required or highly suggested in cases where there is even a possibility of a criminal trial. And in this case, where death was by suicide and not just by some other unknown events, the medical examiner would have either confirmed suicide, leading to most definitely no criminal investigation, or he would have confirmed homicide, which he did, which led to a criminal investigation. There's no other outcome when you conclude homicide other than someone murdered someone else, and that's the statement that you're making, which would lead to a criminal trial.
Let's stop there. Great job, Elizabeth. So we'll do the compliment from Leah before I talk, because then there's less chance that I'll steal what you were going to say. So, what's something Elizabeth did well?
I like how you answered the questions without, like they were hard questions trying to say like you're wrong, and you were like, oh no, actually. So I like how you answered it straight on, and yeah.
Great, I agree. Good lack of reliance on notes too. Like, I didn't felt like you were always having conversation with us, and not like talking at us or reading, reciting. I didn't feel like I was listening to an audiobook. So good style, good substance. First of all, before we even started asking questions, I thought Elizabeth had a nice job of doing the applications of the primary purpose test very quickly. It was almost didn't even realize exactly what was going on, but she was explaining the rule and applying the rule at the same time. And you want to separate that a little bit more in your writing because you have the space for it. But in the oral argument, if you can, there's so little time to get across what you want to get across that I thought it was effectively done. Good answer on the first question. Once again, don't just assume that the premise of a question is correct. So, thought you did a good job of saying why Williams did not target a specific. Why Dr. Hines was targeting a specific individual, or at least why you think so. And then I thought the answer to the second question, that was great. It's like a Perry Mason thing, where like somebody asks a question and you just like turn it right back, like, yeah, well, like if the government had called Hines to the stand, then we would know it. That was great. Good answer on Williams, knowing that it was a plurality. I was kind of fishing for that, and I kind of thought that would be the answer to the question before, but your answer to that was even better. And then you got to the part about how Williams is not controlled because it's a plurality. Don't fall in the trap of the judges pretending that Williams is a binding majority opinion. I'm not even sure how clear the bench memo is on whether Williams was the majority of plurality. Hopefully it at least mentions it was a plurality, but that's the kind of thing that judges could easily skim over in this.
I had two questions. So about Williams, if you're on the prosecution side, even though that case is helpful, do you avoid it because it's plurality, or you just use it?
I would use it.
Okay.
I would use it for lots of reasons. First of all, even though it's a plurality, it's a Supreme Court plurality.
Okay.
Like, this is the court, this is the highest court telling the lower courts, in a situation like Williams, Illinois wins. And whether it was a plurality or a majority, at the end of the day, Illinois did win that case. And so lower courts, in a similar situation, are not supposed to be allowed to let Williams win in a similar situation. Now, the reasoning that the court used to get there, I think the defendant can fairly say that reasoning is not binding. So a big part of that reasoning was targeting a specific individual, and so if I were the defendant, I would not accept that that is the test. But I do think that the defendant has to propose a test, if pushed. The defendant has to propose a test under which Williams would lose, but Miller would win.
Okay.
And if the defendant is proposing a test under which Williams would lose, that's not consistent with the decision of the court majority in Williams. And then I also thought, just one last thought on both Shari and Elizabeth. When you get hard questions, I think you should view that as an opportunity. Because it's kind of hard to shine when you're asked dumb questions. In the same way it's kind of like hard to hit a 400-foot home run when you're throwing a wiffle ball. But like the harder the pitch, the harder your hit is going to be, if you make contact. View tough questions, not gotcha questions. Those are stupid, and like you shouldn't have to put up with that. Or unfair questions, but tough substantive questions that go to the heart of the case, view those as an opportunity for you to really strut your stuff. Who's next? I have a list, so. Bryce.
I went very first.
Bryce went. I don't remember that. You have to go again.
All right.
That's what the list says.
What?
No, I'm just kidding. It feels like you're lying.
It says take Bryce, go again.
It's Taylor. Where's Taylor? Taylor's not here.
Oh.
Go move. Yeah.
You want to go? You want to go?
Let's see. Oh, that's why. Because, yeah. It was Bailey.
Supreme Court.
We got this, Bailey.
I'm pretty sure I go on Friday.
You do go on Friday, although we're going pretty quick. So here's the list. It goes Bailey, Sydney, Sam. We'll get to that. Kelsey, Shelby Hall, Melby, Priya, Zach, Dimitri, and Taylor when she comes back. We'll go first. So, I mean, actually, let's see how many. Oh, shot 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. We'll do 6 today. So, Sharia, Elizabeth, Bailey, Sydney, Sam, and. Are you good to go? Okay.
Good morning, Your Honors. My name is Bailey McCarr. Today, I represent the state in their case against the defendant Ronald Miller for the murder of his wife. I would like this court to affirm the lower court's decision because the defendant's right to confront the witnesses against him was not violated by the state introducing Mrs. Miller's autopsy and death certificate through surrogate testimony. That decision should be upheld because under the primary purpose and formality test, the evidence is more like non-testimonial evidence and the surrogate testimony is sufficient. First, under the primary purpose test provided in Davis v. Washington, the primary purpose of evidence in this case was to complete a routine procedure that is required with any violent death in the state of Brandeis. Precedent provides 3 factors that are relevant regarding the primary purpose test to decide whether or not evidence is testimonial. Here, the evidence is like previous evidence held non-testimonial in Williams v. Illinois because it was produced before any suspect was identified. It is also unlike evidence held testimonial in Melendez v. Massachusetts and Bullcoming v. New Mexico because the defendants there were suspects at the time the evidence was produced.
Great. So can we kind of pause there for a moment? Let's go through each of those cases, and I'll guide you. I'll do it case by case.
Okay.
So let's start with Williams. Expand for us on why our case is similar to Williams.
So it's similar to Williams because it was produced before any suspect was identified. So in that case, it was not inherently inculpatory because the DNA profile on the rape kit actually did produce. It could produce multiple suspects. They had other evidence that led them to convict the defendant in that case.
Okay, and then in Melendez-Diaz, I heard you to say that our case is distinguishable from that. So tell me why our case is different than that, and you can assume that I don't know very much about Melendez-Diaz.
So the analysts were aware of the affidavit's evidentiary purpose in that case, and it was a test confirming the substance seized from the defendant, so they did get that from the defendant.
Okay, and then tell me how our case is different than Bullcoming. And again, just assume that I am not familiar with Bullcoming.
So their law enforcement provided the seized evidence to a state laboratory. And the defendant was a suspect at that time, which is not in our case.
Great. Now the part about the defendant not being a suspect comes, I think, mainly from Williams v. Illinois.
Mm-hmm.
And as you know, that case was a plurality decision with no majority opinion. Talk to us about why we should still care what Williams has to say.
You should still care what Williams has to say because it also has been used to help identify testimonial and non-testimonial statements in other state court cases, lower state court cases. So they use that test. I'm sorry.
That's good.
That was a hard question.
Yeah. I'm going to ask a question I asked your opposing counsel, and that is, what test do you think we should apply? I know your brief gives us both tests, primary purpose test and testimonial, and I know you think you win under either of them. But which do you think is the test we should apply, and why?
I think the primary purpose test provides more factors and provides more relevant facts for determining whether or not the evidence is testimonial. just because it involves looking at whether the evidence was produced before any suspect, whether or not it was made by or to law enforcement, and whether it was made in the normal course of operation, whereas the formality test is still not very established and doesn't have those main three factors. I think that test works well.
And those are all my questions, but do you all have any?
Yeah, can I ask you, what makes Dr. Adler a sufficient surrogate witness?
So she's a sufficient surrogate witness because she was proven, or the original analyst in this situation was proven to be unavailable, and then Dr. Alder was able to talk about the tests that he used, so any inconsistencies with that, and then also came up with her own conclusions based on the facts that were given in the autopsy.
Okay, great job. So I thought that, well, here, before I do all the great things Bailey did,
I thought she was really clear in her answers, like pretty to the point, and answered them without hesitating.
I agree with that. I thought on substance and style, both very good. I feel great about it.
Thanks. I'm obviously really nervous.
Well, that's one of the things that I was going to compliment you on, is that I could tell you were nervous when I called your name to go up, and I could tell you were nervous after it was over. But this is all that matters. I couldn't tell you were nervous when you were up there. I thought you did a great job of not letting the nerves show. You know, there's some line, I don't remember the exact quote, but like that, you know, courage is not the same as not being afraid. Courage is when you are afraid, doing it anyway. You know, there's something analogous there to being nervous, but not letting those nerves get the better of you. And I thought that was awesome. That's also the name of the game for other things too, beyond oral arguments, you know, final exams or bar exam or whatever. It's fine to be nervous, but just don't let your nerves get the best of you. I thought you had good volume also. I thought that on Williams, you did a good job knowing the facts of that case. And then my first question about it, and then on the later question about Williams, I thought that you had a good answer that, you know, why should we care about Williams even though it's plurality? Well, one of the reasons is lower courts rely on it. You know, other lower courts rely on it, and this court should take guidance from those other lower courts. Two suggestions. One is that you start it before I was looking up, or before I said to go. You don't have to literally wait until the judge says like magic words like I am ready. If the judge is like looking at you and waiting for you to start talking, then you can start talking. But if the judge is, you know, fiddling with papers and looking down and hasn't told you to start, and you know, you might ask the judge like, are you ready for me to begin or something like that. And then watch the curse of knowledge thing. Like, you know, Melendez-Diaz, Williams, and Volkoming much better than the judges do. This is going to be true not just for Bailey. It's going to be true for everybody. And so it will be too easy for you to just like talk about those cases as if your audience is familiar with them. But I'm telling you, like, most of these judges have never done a confrontation clause case like ever, and they are not going to know these cases inside and out. Most of them will have basically never heard of these cases until that morning. And so like we spent a paragraph on Melendez-Diaz and the bench memo. Maybe they read it, maybe they didn't. Even if they read it, maybe they've forgotten it. I don't have a photographic memory, and most of them don't either. So they are really only going to know as much about Melendez-Diaz as you tell them. And same for Volkoming, same for Williams, same as all of these things. As much as you tell them when you're up there. So remember the curse of knowledge, second day class. Curse of knowledge. Okay, great job, Bailey. Great job. Okay, who's next? All right, go for it.
Good morning, Your Honors. My name is Sydney Lane, and I represent the state of Brandeis. This court should confirm the lower court's decision that Mr. Miller's right to confrontation was not violated for 3 reasons. First, the primary purpose of the autopsy report was not to be used in a criminal prosecution, so it's not testimonial. Second, the autopsy report and death certificate lack the degree of formality required to be testimonial. And third, Dr. Adler's testimony was a sufficient substitute because she was a reliable witness who testified to her own opinions. When applying the primary purpose test, courts looked at 3 factors. First, if the defendant was a suspect when the report was created. Second, if the report was made in the regular course of business. And third, if the relationship between law enforcement and the medical examiner. In Williams v. Illinois, the court held that a DNA profile of a suspected rapist was not testimonial because at the time the test was performed...
Can I stop for a moment before we get in too far into the weeds of the precedents?
Mm-hmm.
Here's what I think. You can tell me why I'm wrong. I think that the purpose of the autopsy report was not to create evidence for trial when it began. So I'm with you on that.
Mm-hmm.
But I think that as soon as Hines realized that he had a murder on his hands, the purpose of that autopsy report changed. And when he wrote homicide, he wrote it knowing that that report would be used at a homicide trial, because that's what happens in homicides. They get investigated and they get prosecuted. And in order to prosecute a homicide, you gotta show that the victim was dead, and often the cause of death is important. So tell me why. So I think that the primary purpose was to produce evidence at trial, not when it began, but as soon as Hines realized that it was a murder. So tell me why I'm wrong.
So even though he could have potentially realized it was a murder in the middle of it before he reached his final conclusion at the end, Mr. Miller still wasn't a suspect, which is the first aspect of the primary purpose test. He didn't become a suspect until after the autopsy report was completed, and also a criminal investigation did not begin into Mr. Miller until after it was done. Also, the report was made in the regular course of business. Medical examiners in Brandeis are required to do autopsies for any violent death, not just something that may be homicide in nature. So when he started, he believed it was a suicide, and he didn't reach his final conclusions until the end, but he's satisfied, or I guess the defendant can't produce his burden for the primary purpose test because the aspects of the test were followed.
Yeah, fair enough. Okay, go ahead.
Oh, yeah, so Guy mentioned, so you said that you believe the test, or the autopsy report wasn't formal, and what were you using to evaluate formality?
So the report wasn't sworn to in front of a notary public, and it didn't certify the accuracy of his findings. He merely just signed the report, and that was it. So under Williams and Justice Thomas' concurrence, that would not be enough to satisfy the formality requirement.
I'll go back to primary purpose. The cop was in the room.
Mm-hmm.
Doesn't that show its primary purpose was criminal investigation? And let me rephrase that. If the primary purpose of the autopsy was not criminal investigation, why was there a police officer there?
So a police officer in Brandeis and medical examiners have completely separate roles, and it's laid out in a guidebook. The police officer's jobs are to investigate into crimes, and the medical examiner's job is to determine the cause of death. So in this case, even though the police officer was there, I don't think it necessarily satisfies the primary purpose test. For example, a police officer could arrange for an autopsy to be done when there is like a car accident. And just because a police officer arranges that doesn't mean that that autopsy is going to be used in a criminal investigation, because autopsies are used for multiple reasons and not just homicides.
So that's a perfect answer. Expand, my last question, and then we'll be out of time. Expand on the last thing you said, that autopsies have more purposes than just criminal investigation. What are some of those other purposes?
So autopsies can be used for medical research, they can be used for wrongful death suits, they can be used for any suspicious death, in this case any violent death, since suicide is considered a violent death. There are multiple reasons that autopsies are done besides just homicides.
Great. Thanks very much. Good job, Sydney. I'm not surprised, but I thought that was just great, pretty close to perfect. What'd you say?
We're glad we went last week.
I mean, you say that, but like again, everybody's done. I think superbly today.
Oh, they have. That's why I'm like,
and I think part of it is that they're superb students.
Yeah.
But part of it is that like you really can't like give good answers if you're not asked good questions. Or say good questions, but you can't give good answers if you're not asked tough questions. I thought that, okay, let's start. Melvin.
I thought her tone was good as far as I've heard other people and the way she conveyed her message, where it was, kind of like what Priya said, like, this is what I'm saying and these are all the facts to it. I thought her beginning was very strong as well, and then the way she guided the questions.
Awesome. I agree with all of that. My only suggestion is you talked a little fast, particularly at the beginning. No, I'm talking a little fast. But you talked a little fast, particularly at the beginning when you were kind of doing your planned remarks. And I don't know if it was because of nerves or if it was because you felt like you had a lot to say and you wanted to get it in. Well, whatever the reason, everyone remember only 2 stylistic tips, or the big 2 stylistic tips: speak loudly and speak slowly. But that's a small suggestion, and the rest of it I thought really was excellent. Question about the primary purpose. Good job. I have in my notes talking about not a suspect. You came back to that. I thought that was the right answer there. Good answer on the formality question. Good answer when you talk about the guidebook. It's just you knew every test thoroughly. You knew all the facts of our case thoroughly. You knew the state of Brandeis guidebook statutory regime thoroughly. And although your style was very good, you answered the questions directly and you were clear and concise. Good style will only get you so far. And if you don't have good substance, then you're in trouble. And your substance was perfect. So especially, I think the last question, I don't remember what it was, but the second to last, I asked one quick follow-up, but I thought that just hit it out of the park. I actually, just like A+ job there. And today, I'll say this, I'm sure this will continue, but I think the 4 people who've gone today, probably like the best 4 in a row I've ever seen since I've been doing this for 4 years. So, anyway, great job, everybody. Okay. You choose to fill, Sam. We're here 5 in a row. Sam, you're going to be great. I think you're already off to a good start because that shirt sets the bar so low.
Oh, great.
That you can only, as long as you put together 3 complete sentences, that's going to be 1 more complete sentence than the Cardinals had wins last year.
Yeah,
I think that's...
If I'm not afraid to wear a U of L football. Does Duke have a football team?
As a matter of fact, we did not win a game my first 2 years of college.
Oh.
And then when we won my junior year, our first game against some crummy team, we tore down the goalpost. Okay, okay, ready when you are, Sam.
Good morning, Your Honor. My name is Samuel Hoffman, and I represent the appellant, Mr. Ronald Miller. Before we begin, I would like to reserve 2 minutes of my time for a brief rebuttal.
No problem.
May it please the Court. The Constitution's 6th Amendment Confrontation Clause provides criminal defendants the right to confront witnesses brought against them. As Justice Kennedy notes, the clause's underlying purpose is to ensure a fair trial with reliable evidence. Mr. Ronald Miller's constitutional rights were violated when an autopsy report and death certificate were improperly admitted into evidence against him without the accompanying in-court live testimony of the document's original creator, Dr. Michael Hines. This evidence rises to the level of a confrontational clause violation because its primary purpose was to establish or prove events potentially relevant to later criminal prosecution. The Supreme Court refers to this class of evidence as, quote, testimonial. So only statements or pieces of evidence that are given this classification are governed by the Confrontation Clause. The primary purpose of the autopsy report and death certificate was to prove a material fact or establish one, that Ms. Miller's death was a homicide. The statement presents the same evidence that would have been introduced through direct examination of Dr. Hines at trial. The two documents qualify as testimonial because Dr. Hines reasonably believed that the documents would be made available for use at a later trial when he denoted homicide on his report.
Can I stop you there?
Yes.
That's all very helpful. I take it that the Supreme Court has never directly addressed whether autopsy reports are testimonial. Is there a lower court that has taken the approach that you want us to take?
I know there is one.
Well, let me rephrase a little bit, so your opponent's quote, your opponent's brief talks about lower court cases that go their way, that go the government's way, and so you know, even if you don't remember exactly what those cases are, talk to me about, you know, why you think those cases kind of went off the rails.
Sure. So there are some distinguishing factors of the binding cases that we must sort of follow. Most of the Supreme Court's, I guess, interactions with a confrontation clause have been through sort of extremely objective, either laboratory tests or some kind of a document that can be evaluated from a second source, really with no accompanying testimony from the document's original creator. However, I think the thing that makes the autopsy reports distinguishing from these, and why the courts have gone off the rails, is because what goes into filing or creating an autopsy report is highly subjective in terms of the document's creator's I guess opinion, their ability to physically evaluate the evidence themselves and reach a conclusion. So I think the reason why lower courts have reached that determination is because of just the uniqueness of an autopsy.
Great. Great. And then, did you have more? I don't want to totally.
Oh no, I didn't. I guess we can evaluate this later in the argument, but the prosecution offers Dr. Adler as a substitute, albeit an insufficient one, because Dr. Adler was not present at the original autopsy. She had no real interest or part in creating the accompanying report or death certificate, and she did not sign the document either. And one unique factor here is that Ms. Miller's body was cremated after the autopsy. So this makes it completely impossible for Dr. Adler to evaluate the physical evidence herself. So I think those factors all make her an insufficient substitute for Dr. Hines.
So I think that's very well put. You know, I'm struggling with this because I agree with everything you just said about why Adler is insufficient, or at least close to insufficient. But I'm struggling with it because I just can't wrap my head around the fact that medical examiners do die sometimes. I mean, I was listening to a song in the car on my way here today. Jason Isbell is my new favorite singer. And it's something about how, like, you know, if we were vampires, we would live forever. We wouldn't have to, like, make the most of our time. But we're not, so let's hold hands and make the most of our time. And, you know, I think there's a connection there, believe it or not, between that, you know, insight that everybody dies and the defense's argument here, and the government's argument here, that we can't live in a world where every criminal defendant just goes scot-free when he's lucky enough to have killed someone whose medical examiner dies before trial. Can we?
Well, I don't think factual determinations as far as Mr. Miller's guilt, I don't think we're here to really do or conclude. But as far as the procedural aspect of it, while Dr. Hines isn't deceased, he is unavailable. He's overseas serving our country. And that is an aspect of when you're allowed to have a surrogate testify. But we aren't in one of those circumstances here where the defendant was completely, where the where the defendant had an opportunity to cross-examine the original preparer of the documents. The defense was given zero opportunity to cross-examine Dr. Hines before trial. So, in a sense, he was effectively deceased for the purposes of this trial before, because there was no meaningful interaction between the defense and Dr. Hines before this trial or during it.
So I'm going to stop there because we're well over time, but one of the reasons we're well over time is that you're doing a good job, and I didn't want to stop you earlier, and I didn't want to stop you. So good job, Steve. So a lot of the things that I think you did really well. We'll start with William.
First of all, I just felt like your tone was pretty loud and clear. You didn't stumble over words, and then kind of like your argument at the beginning, I just kind of explained what testimonial meant to you, what the court kind of outlines it as, and how you began to explain how it applies to the facts at hand in our case. And then the first question you got, you had like pretty lengthy explanation, and you were able to explain yourself and move on with your argument post question answer.
Thank you. Good. So I agree with all of that. In particular, I thought your volume was great right from the beginning, or especially at the beginning. And your start was great too. You were commanding. You started with the Constitution. Your substance and your style both built up your credibility immediately. And so, like, I as a judge wanted to hear. I didn't want to interrupt you because I felt like I wanted to hear what you were going to say next because I felt like you were not going to waste our time. I also thought that your opening statement was well organized, well structured. I thought that moving ahead a little bit, once we got into the Q&A, you did a good job blasting away at Dr. Adler and why she was insufficient as a surrogate witness. The it was cremated, she can't do it over again, this difference, that difference. But that was all very good. So I really don't have very many suggestions. One thing that everybody, I mentioned before, no reason to have prepared for this, for the practice. But for Saturday, have a list of the cases and have it on top so that you don't have to go look through your notes. But if by some chance you do get asked a question that is in your notes and it's going to take you a minute to flip through or find it, that you kind of looked like, I've done something wrong because I might have to take a moment to find one of these lower court cases, and so I didn't want you to feel that way, so I moved on a little bit. But don't feel like you have done something wrong. It's perfectly acceptable to say to the judges, please give me a moment. I have the answer to your question, but it's going to take me a moment to find the precise information or something like that. And a 1 in 100 chance you get just a jerk judge who's like, no, or like, let's say you're so long, or something like that. I mean, so slim. And when we find out about those judges, we don't invite them back. So 99 chance out of 100, the judge is going to be perfectly fine giving you, 30 seconds, whatever it is, to go through your notes and find the answer. A good judge wants the best answer, not the fastest answer. So don't feel like you've done something wrong in that if you find yourself in that situation. And then I think I asked Sam one of the toughest questions. It's not an original question to me. It's something that the courts that come out in favor of the government talk about on autopsy stuff. It just seems unfair for a criminal defendant to win just because he's lucky enough the medical examiner died already, or is unavailable or whatever. But especially no, it's certainly not the government's fault when the medical examiner died. I think you answered it well, trying to distinguish our case from one where it died. Then I also think part of that answer can be, if you're the defendant, if you have a problem with that result, then you have a problem with the Sixth Amendment, and take it up with the framers. I mean, seriously, the framers created a system where sometimes guilty people will go free, and they did it to protect against a greater risk, which is that innocent people will be found guilty. And in order to protect against that, they adopted some pretty pro-defendant, prophylactic rules. And the Confrontation Clause is one of them. Maybe it's a good rule, maybe it's a dumb rule, That's not for this court to decide. The framers decided. And if we don't like it, we need to repeal that part of the amendment. Okay, good job, Sam.
Thank you.
All right, we have one more today, is that right? Yep. Ready when you are.
Good morning. My name is Kelsey Cole, and I represent the state of Brandeis. Today I'm asking the court to affirm the lower court's holding and finding that the autopsy in Ronald Miller's case did not violate the Sixth Amendment Confrontation Clause. The autopsy in this case is not testimonial for two reasons. First, it fails to meet the standards set forth in the primary purpose test. And second, it fails to meet Justice Thomas's standards in his concurrence for formality. Even if the court finds today that the autopsy is testimonial, Dr. Adler is an expert in the field of pathology and is qualified to give expert testimony based on her opinions in court. The primary purpose test laid out in Davis v. Washington says that when evidence is gathered for establishing facts in a criminal trial, that evidence is testimonial. There are three factors that help determine what the primary purpose of a piece of evidence is. The first factor is whether the defendant was a suspect whenever the evidence was created. In our case, Ronald Miller was not a suspect when the autopsy was started. The police officer...
Wasn't he a suspect by the time it ended?
Yes, he was, but whenever Miss Miller's body was sent to to be autopsied, the officer didn't even check for gunshot residue on any person's hands at the crime scene.
But if she was a suspect by the time it ended, doesn't that mean that the report isn't that what matters?
No.
Tell me why.
Because whenever you look at precedents like Melendez-Diaz and Bullcoming, they come out inside of the defense. When you look at those cases, the person was already in custody whenever those reports were made. In our case, that's not the case. Even though whenever it came out, they knew that it would be used in a criminal investigation. Dr. Hines the record doesn't even show that he knew that Ronald Miller would be a suspect in the crime.
What if, let me give you a hypothetical. It's just like Melendez-Diaz, but with one difference. Melendez-Diaz is suspected of cocaine. They find cocaine in the car that he was selling out of. They test the cocaine, it comes back positive. All same thing. And all along, he was the only suspect for the person whose cocaine it was. Because it was like his car was the only one in it. Maybe the cop even saw him like drop the bag of cocaine and run away. And they tested cocaine. But here's what makes the hypothetical different than Melendez-Diaz. He's not in custody. He's actually on the lam. But they still, while they're looking for him, run the cocaine test. Wouldn't the cocaine test there still be testimonial, even though he was not in custody?
So our case is different from that hypothetical because the regular course of business of a medical examiner is different than the situation that you just described. There are lots of reasons for an autopsy, and some of those reasons are laid out in People v. Dungo. You can see that families often request autopsies, insurance companies will request autopsies, they're done for medical research, etc. So the fact that autopsies are done for a multitude of purposes kind of disaffirms that hypothetical.
That's good. Let's talk about Williams. I asked earlier, I'll ask you a similar question. The reasoning of the plurality was rejected by a majority of the court in Williams because it was rejected by the 4 dissenters and was rejected by Justice Thomas. Why should we still care about what the plurality said in Williams?
Williams is still a Supreme Court case. It shows that the state of Illinois won in that situation. So situations similar to that where there isn't a suspect whenever the report is created, the state should win in those types of cases. The reasoning, you could get there different ways. but I still believe that case shows the trend that the court is moving toward and how they are willing to decide those cases.
What about there was a surrogate witness in Bulkamane. Bulkamane was the blood alcohol test case. And the court said surrogate witness is not okay. How is Dr. Adler different than the surrogate witness in Bulkamane?
Dr. Adler, she had a lot of testimony or questions from the defense in the trial where they asked specific facts, not just about the process of what happened in the autopsy, but facts that would be true whether or not she did the autopsy or not. So facts, they asked her questions about stippling patterns, whether or not they wash away in water, and she can answer that question without doing that autopsy. Those are true facts whether or not she even saw Mrs. Miller's body. So if you look at the record, there are multiple examples of the defense asking those types of questions, and that's where our case is different from Bulkamane there.
Awesome. Awesome. Do you have any questions?
Good.
Good? Good? Great job, Austin. You left us speechless. Let's see, who's up? Yeah.
Yeah, I thought you did do a really good job absorbing some of his tough questions and kind of sticking to your distinction between your cases. And then when you added the people versus Dungo, that was great timing.
That's good. So good. I thought one of the best things you did was before class even started. I had not guaranteed that you would go today, but you were prepared to go today. And I could tell because as soon as you got up there, you knew exactly what we were talking about, and you had some notes, and like you were ready to roll. And so, great job being prepared, even though you weren't sure you were going to go today. Good answer on, I think it was my first question. So, like the test should be, are you in custody again? And so, even if Miller was a suspect by the end of the autopsy, that's not really the test. The test that's coming out of Williams is, are you in custody again? So I thought that was good. Then as to the hypothetical about in custody, and I thought that you did a good job with your answer. That's one suggestion. You switched pretty quickly from the in custody factor to the course of business factor, and I think that it would have been better to quickly answer the question directly about the in custody hypothetical, and then after you quickly answered it, pivot to what you did and the course of business factor, so that the judges realize, like, no, you're not putting all your eggs in the custody basket. There are other factors too that are really important, and you win under those factors. So I thought that was a good strategy that was executed very well. Could have been executed even slightly bit better by just giving another moment to an answer to the actual question before you pivot and go on the offense. But good job pivoting. Good answer on why Williams matters. I like to use the word trend of the Supreme Court, and I think that's kind of the answer to this case if you're the government, is like, yeah, like Melendez-Diaz and Bulkamane, those are tough precedents. But this is an area of law that's in flux, and the trend is toward the government. You can't like define that exactly. There's not like a line from a binding precedent that proves that, but I think it's the reason why the government is probably right. I don't know if the government's probably right. If the government's right, I think that's the reason why. And then finally, I thought maybe your best answer was on the Bulkamane surrogate witness difference. You knew the facts of our case. Good example, something we talked about early on this semester. Even though the purpose of an appeal is not to relitigate facts, it is still really important to know the facts of our case, because appeals are about applying a legal rule to a set of facts. We don't get to debate what the facts are, but this winning depends on how we apply the rule to the facts when we all agree with the facts. And so you can't win that argument unless you know what the facts are. So good job, knowing the record of our case really well. So great job, Kelsey. Great job, everyone today. What an awesome day, all 6 of you. I'm just in for a disappointment with the next class.
Do we need to have to say, may it please the court?
You don't have to.
Okay.
I think that for the oral argument competition, they probably prefer that. I think you should. In practice, I would say before the Supreme Court, but not before lower courts. But, you know, maybe if I were a lower court judge, I would want lawyers to say it behind it. Yeah, Shari.
Yeah, any tips on starting the rebuttal? Out of phrase?
Yeah, good question. I would point to something your opponent said or something the judges said, and then respond to that. Because the purpose of a rebuttal is not to repeat your argument. It's the only reason you get a rebuttal is because the court thinks it's important for you to be able to reply to stuff that was said. So don't do it in a hostile way. It's like, my foolish opponent said this ridiculous thing. Here's why that's totally wrong. But, you know, if I may begin by responding to my opponent's assertion that blah, 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 you know, I think that argument is mistaken because, you know, that's my advice. Begin with something, or if I may begin by responding to your question, the right answer to it is whatever, maybe some question that the judge asked your opponent. Or if I may begin by responding to something you said that I think that I strongly agree with. You said, this court said, you know, and then if the judge says something good for your side, then you like say that, remind the court that they said that, and then expand on that. That can be good